She is a retired Australian school teacher living in Canberra, which is the capital of Australia. And it is like Washington, D.C., not a part of any state of Australia. It's a separate territory. And she's here to talk to us about a conflict that exists within the laws in the territory, mainly the Capital Territories Law of Crimes Act and the Human Rights Act. So without further ado, I'm giving you Jean Arthur. She's going to talk to you about our website.
Thank you very much for having me to speak to you today. What I want to do today is to talk, in this talk, is to look at some work that Dying with Dignity ACT has undertaken in relation to human rights that addresses suicide and analyses 3 famous suicides from history for what we can learn from them about suicide today. Now, you might think, why am I talking about suicide when you're all here about the right to die for people who are older? Our view is that suicide is absolutely integrally connected to the issue of the right to die at the end of life. So that's the main reason. Included in this work is a possible model for what we have chosen to call an elective death that would allow a respectful end of life to all citizens in any community who want to manage their own death. In the Australian Capital Territory where I live, we have a couple of laws that influence the discussion of making a choice to die. The first is 1988 ACT Self-Government Act. It states the Assembly has no power to make laws permitting or having the effect of permitting the form of intentional killing of another called euthanasia, and in brackets they add, which includes mercy killing or the assisting of a person to terminate his or her life. So the very fact of the way they define euthanasia not being a good death, but the intentional killing of another person, tells you exactly what the federal government of Australia thinks about euthanasia. The second is the ACT Crimes Act 1900, which states, Section 16, the rule of law that it is an offence to commit or attempt to commit suicide is abolished. Section 17A, Section 17, a person who aids or abets the suicide or attempted suicide of another person is guilty of an offence punishable or on conviction by imprisonment for 10 years. And I think you'll know from your own laws that 10 years is fairly minimal. It can be life imprisonment if you're in the wrong place. If a person incites or counsels another person to commit suicide and the person commits or attempts to commit suicide as a consequence of that incitement or counselling, the aforementioned person is guilty of an offence punishable on conviction by imprisonment for 10 years. Section 18, it is lawful for a person to use force that is reasonable to prevent the suicide of another person or any act that the person believes on reasonable grounds would, if committed, result in the suicide of another person. Dying with Dignity ACT has been trying to wrestle with the impact of these 2 laws by looking at a third law, the ACT Human Rights Act, to test whether they can be challenged. Our first attempt was to test the Crimes Act legislation on the basis of incompatibility between the Human Rights Act and the relevant sections of the Crimes Act by making a claim of discrimination. And I think that this claim is probably absolutely essential to the discussion of the right to die. The Human Rights Act states in Section 8, recognition before the law, everyone has the right to enjoy his or her human rights without distinction or discrimination of any kind. And it draws on Article 26 of the International Covenant on Civil and Political Rights, which states that all persons are equal before the law and are entitled without discrimination to the equal protection of the law. In this respect, the law shall prohibit any discrimination and guarantee to all persons equal and effective protection against discrimination on any grounds, such as race, colour, sex, language, religion, political, or other opinion. Now, when I looked at this, I thought, I couldn't believe my eyes, because I thought, you know, this is really essential to what we're on about, that we can have an opinion and we can be discriminated against on the basis of our opinion, or not discriminated against. So other things that are included in this is national or social origin, property, birth, or other status. Dying with Dignity ACT argued that the opinion underlying Section 17 of the Crimes Act is that people must die a natural death of the diseases of old age. If they don't, they are submitted to a degrading and usually painful manner of death, for example, hanging or act unlawfully to obtain a peaceful means of death. So, in other words, for all of you who are in the know, that means somehow trying to get hold of Nembutal. This opinion discriminates against those who hold the opinion that they should be able to undertake their deaths in a safe manner within a modern health system at the time of their choosing. The belief in the right to determine your own death is a long-held cultural belief in Western and some Asian cultures, evidenced in literature thousands of years old, which should be respected, but is treated with contempt by the cultural assumptions behind Section 17 and 18 of the Crimes Act. The result of this discriminatory opinion is that various other sections of the law are being breached. In Section 10 of the ACT Human Rights Act, it is about protection from torture and cruel, inhuman or degrading treatment. It states that no one may be treated or punished in a cruel, inhuman or degrading way. Dying with Dignity ACT argued that Section 17 of the Crimes Act forces people who want to die horribly. It sanctions self-assault, and Section 18 allows assault by others on a suicide. Section 12 of the ACT Human Rights Act is about privacy and reputation. It states that everyone has the right not to have his reputation unlawfully attacked. Dying with Dignity ACT argued that the act of suicide is treated as a great shame to be hidden. Suicide is kept quiet. It is discouraged. It is always regarded as a great tragedy. The label suicide, while lawful to use, is demeaning and reflects the general failure by society to understand that to end one's life is a choice a person can intentionally make in the exercise of their own lawful right. The choice is not respected as a choice that is made like every other choice people make in their lives. So I think if you're following what I'm saying, from that belief that everyone should have a death by disease, a whole lot of other discriminatory things happen. That people are being treated in appalling ways as a result of that. In Section 18, the right to liberty and security of person of the ACT Human Rights Act, it states everyone has the right to liberty and security of person. Dying with Dignity ACT argued that Section 18 of the Crimes Act gives permission to other people to assault a person who wants to end his or her life. Section 17 denies the person wanting to die the liberty to undertake his or her death or to undertake it except by insecure means, that is, self-assault. Section 28 of the ACT Human Rights Act states that the Human Rights Act may be limited, that human rights may be subject only to reasonable limits set by territory laws that can be demonstratively justified in a free democratic society. Dying with Dignity ACT argued that Section 17 is not a reasonable limit on the human rights to die, expressed by Section 16. Swiss law has demonstrated that it is perfectly reasonable in law to assist suicide. One purpose of the limitation posed by the ACT law is, sorry about this, to prevent people dying early, but it is not effective as people continue to suicide at the same rates despite the law and other measures. The Swiss have demonstrated that it is possible to provide a reasonable, less restrictive limitation. Part 4 of the ACT Human Rights Act is the application of human rights to territory laws. Section 13 on interpretation of laws and human rights states that so far as it is possible to do so consistently with its purpose, a territory law must be interpreted in a way that is compatible with human rights. Section 31 on the interpretation of human rights laws states international law and the judgment of foreign and international courts and tribunals relevant to a human right may be considered in interpreting the human right. Dying with Dignity ACT argued that Section 17 of the Crimes Act 1900 is incompatible not only with the implicit human right to die expressed by Section 16 of the Crimes Act, but also with the inherent dignity of the human person identified as the source of all human rights in the International Covenant on Civil and Political Rights, which applies to everyone in the world, not just the ACT, to everyone. The double standards and internal contradictions in these laws must be evident to anyone who thinks through the consequences of these laws. It is no longer a crime to commit suicide, but no one can help anyone to suicide. The laws have wide-ranging detrimental impacts on the inherent dignity of the human person. 1. For the terminally ill, no doctor will help them except to give symptom relief, even if they beg for death. Any doctor who does help another to die, and they do, becomes a criminal. 2. For suicides, they are forced to hang, gas, jump off high buildings, poison, drown, or shoot themselves. 3. For attempting suicides, they are left untreated and unsupported. 4. For families of suicides, they have had to go through the trauma of losing a loved one to a violent death. 5. For people who deal with suicide, such as ambulance and medical staff, they are subjected to the trauma of seeing hanged, shot, poisoned, drowned individuals. Section 16 allows it is lawful to end one's life, so it should be able to be done in a humane and respectful way. Swiss law has shown that it is possible to do that perfectly safely. People who elect their deaths are as entitled to have safe, respected deaths as those who do not so elect. At the same time as we made this submission, we developed a model of what an elective death might look like. And I've distributed a paper around to you. On one side of it has the copy of the elective death model, and on the other side we have the statement of our aims in our constitution. So I only made 50. I was told that there would be 50 people in the audience maximum, so I made 50. So if those people who have it might share between two or whatever, that would be helpful. So basically what it is a model of how an elective death might look, and some principles that govern how that might look. If we've got an option of photocopying it, I'll make it more available to people. So in our submission claiming discrimination, we argued that we had a cultural basis to our belief in the right to determine your own death. So today I'm going to briefly look at that cultural background. My first subjects are probably the most famous pair of suicides in world history, Antony and Cleopatra. Now, you probably don't think of Antony and Cleopatra as suicides, but that's what they did. That's how they ended their lives. They suicided. We think probably of them as for other reasons, for their love story or whatever. And in fact, their love story is also an important part of why they suicided. And a very good reason for people choosing at the end of their lives to suicide, to die together to not be left alone in life, having to, make your own way through the rest of, say, a couple of years. Anyway, Antony lived between 83 to 30 BC and was in his 50s when he died. Cleopatra was 39 when she died soon after Antony in 30 BC. This couple is so famous they have become almost mythical, but we know they were two real people because of Plutarch's history of their lives. So I'm drawing on Plutarch's history when I'm talking about them. In brief, Mark Antony and Cleopatra shared the rulership of the Roman Empire with Octavian, Caesar's nephew, after Caesar had been assassinated by other Romans committed to the Republic when they saw that Caesar was intent on seizing control for himself and becoming a tyrant. Octavian eventually declared war on Antony and Cleopatra, defeating them at Actium. Plutarch states that Antony thought of committing suicide a number of times before he finally did, but on each of these occasions he was hindered by his friends. Antony's final decision to suicide came when he thought Cleopatra had died. Plutarch quotes him as saying, "Now, Antony, why delay longer? Fate has snatched away the only pretext for which you could say you desired yet to live." So those sorts of comments are the reason why these are a famous couple, that they lived for each other, they loved each other deeply. Antony, being a Roman general, attempted to die by falling on his sword. He seriously wounded himself, but he died slowly of blood loss. Octavian invaded Alexandria, where he made every effort to calm Cleopatra's fears and implied that she would have everything she wanted for her children, and treated her and her children honourably. He also allowed Cleopatra to bury Antony in splendour. Eventually she learned that Octavian intended to take her and her children to Rome. Plutarch quotes her as saying, at Antony's grave, two things that can be seen as her motives for her choice to elect to die. "Let me not be led in triumph to your shame. Nothing has afflicted me like this brief time that I have lived away from you." She chose a peaceful death by poison. So this, to my mind, bears very heavily on our argument that what we're talking about here is a choice. We have made a choice that everyone should die of disease. At this moment, Cleopatra, 2,000 years ago, found a peaceful way to die herself. But because of prejudice, this is not a choice that we have made for ourselves. My other subject for this talk is Cato. Cato was born in 95 BC and died in 46 BC. Cato lived right at the time of the conflict between those Romans who favoured a republic and those who favoured Caesar. Cato aligned himself with the Republicans. In relation to his suicide, there are two important factors: Caesar's increasing dominance and Cato's belief in suicide, which was part of his belief in the ideas of Stoicism. A Stoic believed in living a simple, upright life. Cato was a model for the Stoic philosophy, being a man of high integrity in everything he did. After a life of honourable public service, he found himself in a city called Utica, attempting to protect the lives of everyone in the city. He helped all those that could to depart by sea, but already every class of men in Utica could clearly see that when he had secured their lives, he might put an end to his own. His relatives and friends, fearing his intentions, removed his sword from his room. Eventually, Cato became angry when it was not returned to his room. Plutarch describes the reaction of his son and friends. Then his son, with the rest of his friends, came running into his room and, falling at his feet, began to lament and beseech him. Cato replied, "When and how did I become deranged and out of my senses, that thus no one tries to persuade me by my own reason? And you, your father Father's hands behind him, that when Caesar comes, he may find me unable to defend myself. So clearly for him, suicide was a choice of strength and defence. When the sword is finally returned to him, he is quoted as saying, "Now I am master of myself." After inquiring about the fate of those who had left Utica, Cato took his sword and stabbed it into his breast. Today we would be encouraged to make a judgment that the decisions of these healthy individuals were cowardly and that they should have been more resilient. Their contemporaries were saddened by their choice to die, but they admired them for what they had achieved in their lives and their spirit. I've provided this brief glimpse of the cultural background we have inherited, so it's possible to see that the right to manage one's own death has always been challenged by authorities of one kind or another, but equally it has been asserted by individuals. Not giving people assistance to die is both a powerful tool and a sleight of hand by government. Without our knowing it, our bodies no longer belong to us. We are required by law to die of disease to prove that we were not murdered. The law that suggests that the government is doing us a favour by ensuring that we have a natural death and we are protected from murder. Not giving assistance to those who suicide is a carefully controlled story. The statistics about suicide are not widely known. The method of death is not told under the excuse that people might copy a suicide. Suicide prevention is touted as effective, and its effectiveness is not discussed. The fact that the law ensures a cruel death or illegal behaviour is not something lawmakers want to discuss. In fact, in the ACT, what I have found over the last, I've looked at the statistics since '96, and there's been no change, despite we have organisations called Beyond Blue and Lifeline, and I'm sure you all have those sorts of organisations. There's no evidence that they make any difference whatsoever. So what the law does is force people who want to die into making all these horrible choices. To return to the present, the ACT Attorney General's response to our submission was that the ACT government could do nothing because it was, one, prevented from making laws on euthanasia, that's by the '98 Self-Government Act. Two, that our elective death unit would allow healthy people to die. And three, we should address the human right to life. The Human Rights Commissioner wrote back to us saying that the Commission would do its own analysis of our claim. When we heard nothing, we pressed her further, and finally the Commission assisted us to find a law firm in Victoria, a state which does not have federal government legislation preventing it from making laws on euthanasia. The law firm Justice Connect seemed willing to make some moves to assist us, but wanted to find someone in Victoria to be the complainant. I've approached an individual Victorian who's taken up our ideas with Justice Connect, and I don't know how that will go. Who knows? If you don't have someone really committed and determined like me, things don't happen. Dying with Dignity ACT responded to the remarks of the Attorney General by making a further submission to the ACT Human Rights Commission, which addressed the right to life and the right to practice one's belief. When I first looked at the ACT Human Rights Act, I didn't think that the right to life was relevant. I thought that, you know, everyone wants the right to life, no one wants to be murdered, you know, that's the way it goes. It's not something you can address. So I was quite sort of concerned about addressing this particular law. So this is our go. We decided
3 minutes.
3 minutes. Oh, okay. I don't have enough time. All right. Okay. Well, what I will do is just summarise then what we decided. The main thing that we chose to do with the right to life The actual right is every person has the right to life and has the right not to be arbitrarily deprived of life. So we decided that, first of all, in looking at that, the law says that every person, the law is about every person. It's not about the state saying the state has the right to protect every person. It's about every person. So if someone comes at us with a knife, ultimately, we are the person. We have to defend ourselves. It's not the state. The state is not there in the form of police officers who will suddenly appear in front of us and so on. So it's each of us as individuals. The other thing that we looked at was the business of arbitrariness, and we said that nature is the most arbitrary of all methods of death. So in every way that you look at the word arbitrary, and nature is the most arbitrary. That's the second point. And in the end, we decided that the state, in fact, in forcing us to have the arbitrary, this arbitrary death by disease, is forcing us to be subjected to an arbitrary death rather than one that we can have control over. So everyone should have, what we're arguing is everyone should have the right to control their own deaths. I've really missed out the most important thing. The other law that we have challenged is everyone has the right to freedom of thought, conscience, religion, and thought, conscience, and religion, and the right to practice their own beliefs. So we are arguing, as an incorporated body, that we should have the right in the ACT to determine the way we die because of our beliefs. And that's what we intend to do. We intend to take up the step of arguing that as a group we have a set of beliefs about how we should die. We believe that we're being discriminated against in terms of the way we should die, and that the state has no right to determine how we should die. So everything is on our website, dwdact.org.au. So you're welcome to have a look at the full speech. Please do so. We believe we're actually involved in a political debate, and we really think that as a group of people who have a set of beliefs, we are being discriminated against, and we don't want it to happen anymore. Thank you very much.
Our next speaker is a psychiatrist from Holland, Dr. Chabot. He is an author, and his books are on sale in the back of the room. Two of them were just published this year. One is on SED, stopping eating and drinking, and the other is on the helium method and the medication method. And the videos describe these methods with professional actors. He's been involved in litigation himself for doing things that other people didn't think he should be doing, and he might tell us a little bit about that. This morning he's going to talk to us about another case, not his own, that's on its way to the Netherlands Supreme Court. It's about a man who helped his 99-year-old mother died and showed what happened in the process of dying on television. I mean, he was really asking for it, so we'll hear the details.
Thank you. I'm from the Netherlands, but this morning only when listening to Larry Egbert's talk, I realized I'm from a different planet. And I guess you'll understand later today. Because this Chabot case in the Supreme Court, in 1991, I handed over a lethal cocktail of barbiturates to a 50-year-old social worker who was very healthy, had many friends, but her 2 children had died, one by suicide, had shot themselves, and the other had early cancer, and from that day on she was searching for a humane death, and in the end she persuaded me that there was no willingness, no openness for morning therapy, and I handed over the lethal cocktail and had to go. Of course, I immediately reported this. No police came. I reported it to the coroner. I was not arrested. I was not in jail. I was treated with respect by the judicial authorities, and so it went up to the Supreme Court. That is, apparently already then there was a different cultural climate, which seems to be hard to find here. Okay, my second. I'm sad there is no one to help me to make it full screen. Perhaps, Henny, you can... F5. F5, okay. Okay, we've had my talk will be about the case just mentioned, and this is typical a case of old age rational suicide, which you will hear about tomorrow by Michael Irwin much more, but this is a legal case that is expanding the law in the Netherlands for elderly people without any serious illness who want to die. Tomorrow morning there is another frontier where the Dutch are moving on, the early dementia cases who ask to be helped to die, and if they are still competent, some of them have got this, but it's still argued because it's a tricky issue, like the third frontier, giving assisted dying to psychiatric patients. That's tomorrow afternoon a topic, so let's focus in my presentation on the old age rational suicide. These are the bare facts of the case. You can read them. His mother was reasonably healthy at age 99. Her second grandchild was coming up, but she said to her granddaughter, this was the great-grandchild, of course, she said to the mother who was pregnant, I don't want to see this child, I want to leave the world. And then no sign of depression, no illness, she was definitely not lonely, had the normal impairments of old age, and asked her GP to die. And some of you may think that in the Netherlands doctors are willing to do that, but most doctors are definitely unwilling, so this GP also turned down her request to assist her death. What happened then? She searched with the help of her son, who talked to her about stopping eating and drinking, but some people have an emotional aversive reaction to that way. It is possible in elderly people with good palliative care, but if there is an emotional aversive feeling about it, don't try. So she didn't. At the time, in 2006, there was no information on helium available in the Netherlands. And she went her own way. She saved the temazepam. Luckily, she told her son that she intended to take them one day, and he got the response, "Don't do this. I mean, you will wake up, it will be horrible." But he didn't step back. He didn't leave his mother alone. He understood her wish, and he wanted to assist her. And what did he do then? And that is crucial. The doctor had refused. The son had good information about the chloroquine method, which most of you probably will not know, because nowadays pentobarbital is much more en vogue. But he had a lot of chloroquine tablets he had saved during his work in Africa. And he knew the lethal dose, which few people know. That's 11 grams. And he also knew that it is crucial to add diazepam, a long-acting benzodiazepine, which he ordered. It's not so difficult to order through the internet. This is crucial to have deep sleep when the chloroquine does the job in your body like pentobarbital does, but the difference is that pentobarbital does both, killing you and giving a deep sleep. In chloroquine you need the diazepam. And also important, how should this be taken? He knew that. All this I've written down in much more detail in my book, which is at the back of the this place. It has just appeared. Methods for Humane Self-Chosen Death. It discusses several medication methods. In chapter 2, among others, the chloroquine method, which is very effective, just as effective as pentobarbital, but much easier to get hold of. And of course, it discusses the helium method in detail, as well as many other methods that are not effective, are even dangerous. Well, Heringa took precautions. He understood that after her death, the authorities had a right to know what had happened. So he recorded the conversations, several, in which her granddaughter talked with Mook about her death wish. And after the decision had been taken, he recorded how she sprinkled the chloroquine tablets in yogurt or custard and took them. When she was deep asleep, he didn't want to raise suspicion in the house where she lived, so he left her and was phoned next morning very early that his mother had found dead. A doctor on duty had immediately been warned, and the doctor had signed a declaration of natural death, which is of course a thing I think will happen here. If a 99-year-old lady is found dead one morning, no one will think about anything. So there was anything criminal or whatever. So when he came, he could continue. But of course, he had to keep the secret. And 5 years later, there was an occasion in which he decided to stand up for what he had done and hand over the video recording to a broadcasting company who showed it on TV. And the very same day, of course, his lawyer made contact with the authorities and prosecution followed. Now I want to get quickly through these data, so I give you the verdict, and if there are any questions on a particular slide, we can go back to them soon. The lower court said, this was last November, guilty without punishment, and after a full-day sessions of the court, the judges were convinced that Mook's wish to die was well considered and there was no undue pressure on her to leave this world. The case will go up, of course, we don't know when yet, but it will take some years to reach the Supreme Court and see whether what Heringa has done is indeed acceptable according to the Supreme Court, or perhaps which has been a jail sentence or other sentence come up. So it's still, what were the deliberations of the court? Dutch penal law explicitly forbids assisted dying, especially handing over lethal medications. But there were three other important considerations. The Supreme Court has allowed relatives to be present at a self-chosen death to provide moral support. Well, that was the basis for Heringa to remain present. Sensibly, he filmed her. The prosecution could provide no good evidence that Muksan had pushed her to die earlier than she had wished. And of course, the recording of the conversations with her granddaughter were very important in this to convince the court. And up till, well, over the past 40 years, there had been no case law about a relative who assisted in a suicide. So there's really a new thing to do. This is my last slide. It's not only, the Netherlands is not only in isolation, it's in the European state federation, I should say. It's not a state, European Federation. And this has a higher court than our Supreme Court, though the exact interaction is not yet completely clear. But if this case of Heringa goes up to the Supreme Court will have to pay attention to this, watershed case of a man named Haas versus Switzerland, the public prosecution of Switzerland. And in that verdict, the European Court has confirmed that there is a basic right. It's, I don't know, I can't say a constitutional right because the European Federation has no constitution, but we have, the European Federation has basic rights, and number 8 of them says that there is a basic right to have a private and family life, which includes the way and the time to choose your death, to choose the way and the time of one's death. And the implications of this European Court have to be still assimilated in the different countries, also in the Netherlands. But in the light of this right to a private and family life that extends to choose when and how to die, perhaps Heringa has a good chance to be cleared of all indictment. Thank you very much. Perhaps there's time for questions.
Well, we've got some time for questions and answers, and I will repeat your question.
Oh, good.
Yes, lady.
I would like to know what the public's reaction was to Reagan's video. What's the general feeling in the country like?
The question is, what's the reaction of the general public in Holland to the video?
Extremely positive. It's just in one word. When the video was broadcasted in 2011, many people felt this is as it should be possible. But be aware that the doctor had refused, and many doctors will still, and in the future, I think, as far as I know, Dutch doctors refuse. There are some who would be willing to give assisted dying, but many will refuse. So it's only because her son had the information and took the information to her, discussed it with her, took his precautions, that things are going as they are now, which is very positive.
Question over here, you lady in the purple.
Isn't euthanasia legal in the Netherlands? So why is this questionable?
The question is, if euthanasia is legal in the Netherlands, why is this an issue?
But when it's legal, it's not yet a right. I think that is the main misunderstanding of the Dutch situation. Euthanasia is legal if a doctor conforms to the duty care conditions. But it's never a right of the patient, because a doctor has his own moral position, and he can feel it's wrong to kill another human being. Anyway.
And this was done without a doctor, right?
Yes, the doctor didn't know about it.
Couldn't they go to another doctor?
Could she have gone to another doctor?
Good question, because that is what the court reproached on the first day. Albert Heringa, his son, why didn't you try another doctor? And, well, he had a strong defense. At the time, perhaps now he could have, but in 2006, no other doctor would have accepted a patient from O'Connell who was looking for assisted death, and even today it would be very difficult.
Question back there?
Do you think that among the medical community, the Dutch medical community, that the reason for turning down this request for death, do you think that it's on the ethical side or on fear of legal repercussions?
So the question is, was the physician's, general physician's refusal to help her on the ethical side or fear of repercussions?
More, well, both play a role, but the majority is ethical considerations. Many doctors now accept to provide assisted in dying in terminal patients who have, an illness that will be lethal in the near future or in the longer future. But if there is no serious illness, then many doctors have ethical they put themselves on a distance. They feel that is not their job. They have not become doctors to kill elderly patients who want to die. And there are still some doctors who fear legal consequences, but I think this is a dwindling minority.
Yes.
I'm still a little bit confused. If it's euthanasia is legal, but it's illegal to assist in suicide, is the difference based upon the definition of euthanasia and suicide, or the fact that the doctor is assisting versus a relative assisting?
Well, I don't understand the question, because I've not said anything about illegal.
Well,
I said it's
being
legal.
prosecuted for assisting in a suicide, that's not, it suggests that there's something illegal about assisting someone.
Okay, I understand. This Article 294 of Dutch penal law says, in general, that it is illegal to provide lethal medication. But 12 years ago, there was a law accepted in Parliament that doctors are exempt from this Article 294 if they conform to the due care criteria that were specified in the law, 6 criteria. So doctors are exempt from this article, but relatives not. So that is what Albert Heringa is fighting for. And many people, with the sympathy of the majority, I think that relatives, in the privacy of their home, in the privacy of their intimate sphere, can assist. Of course, they have to provide evidence after death that they have not pushed the person, that the person has executed the lethal acts herself. It's not something you can put into the mouth. I mean, you have to record that someone does it oneself. And this was so clear from the recording of Mook's, the way Mook did it.
Question over here. Question?
So then if doctors are exempt and are able to provide lethal medications, are there doctors who do specialize with just this, or are there many other 90-year-olds out there that couldn't find a doctor to help them?
The question is, are there doctors who will assist, or are they still hard to find?
Doctors, can you repeat it?
The question is, if I understand it, are there The problem was there were not sufficient doctors willing to come and help Monk.
Correct.
Now, are there sufficient doctors so that this isn't a problem anymore?
If it's legal, why was it a problem finding a doctor to help? Is it just because none of them agree ethically?
My answer is the same. If it's legal, it's not yet a right, and doctors have no obligation to provide assisted in dying in cases where they think this is against their moral position.
So it is legal, it's just the number of doctors are not ethically on board.
I'll stay up here.
Could you please repeat the last part?
I was just trying to clarify. It sounds like you're saying it is legal and they could, except that the majority of doctors are not ethically on board.
What is ethically on board? What do you mean?
Agree. They don't ethically agree.
No, there is the majority. This has been substantiated in research.
Thank you. Okay.
The majority will not do it.
Okay.
There's a question in the back, the lady standing.
Did she buy the medicine herself?
Did she buy the medicine herself?
No. Her son bought them when he was, for his working travels in Africa. He brought them with them at home, but not with a specific thing in mind. But, well, if you travel to Africa, you often use chloroquine. So he had a sort of...
What about the other medicine that she needed?
Yes, he definitely bought the long-acting diazepam, the Valium. He bought them through the internet, yes.
Okay, question back there and then up here.
I'm wondering how doctors are responding to the idea that it may not be just their exclusive, no matter how difficult it might be for them or how many might not want to do it, but the idea that it might be possible for relatives to help someone die, whereas before it was only doctors. Is that a problem within the medical profession?
Well, that's what this case is all about, but the question is it okay now for relatives to help? I think that...
How do doctors feel about that?
Oh, how do doctors feel about that?
Doctors are divided. Because this is really, the verdict was in October 2012, so it's still in discussion, and it will continue the discussion in the higher court and then in the Supreme Court. Doctors are still divided. Some feel, oh well, if this is possible, then I can stick to my physician-assisted dying in very ill patients who can't possibly do it. And other people can do it themselves. But there are, of course, also doctors who think, well, perhaps I should widen my ethical boundaries.
All right, question here and then over there.
Even if relatives are in general, they would need the help of a physician, not why to relatives.
The question is, can the relatives get information from the physician about what to give to their parent, how to get it?
In my experience, doctors don't know anything about this. And doctors learn from the relatives who come up with, not this book, because this has only appeared last month, but with previous information I've published. And they say, oh, well, that's new for me. I don't learn about that in my training. This is going to change. I've been asked to write a chapter in a book for doctors who become general practitioners to, well, how they can, what the information is, which means they are better equipped to discuss it with the relatives. But nowadays, the initiative is with the relatives who find the information in my books.
Question over there.
Yes, along those lines, is the Hippocratic Oath universal, and is that what guides ethical decisions by the doctor? When they say it can do no harm, that used to be part of their training in the U.S. I may be out of date.
The question is whether the Hippocratic Oath that doctors will do no harm, is that still applicable?
I don't think so. As I said, the Netherlands, it seems to be on a different planet, not only across the Atlantic. No, doctors feel it's part of their duty to relieve unrelievable suffering, if necessary, by providing assistance in dying. But from the beginning, this was meant for people with very serious illnesses, lethal illnesses. And now the situation arises that many elderly like Brooke, feel it's enough. And then it's not a question of no harm, it's a question that is your identity as a doctor feels threatened when you start killing people who could do it themselves, who could take responsibility themselves, like Brooke did, together with her son. Okay?
I think we're out of time.
Again,